In 2021, Arizona implemented regulations allowing the creation of alternative business structures. An alternative business structure, or ABS, is basically a law firm that's owned in whole or in part by someone who's not a lawyer. In my work, I advise and help a lot of ABSs. Our team consults with ABSs as they apply and afterward when they're doing business. Over the past few years, as the environment around ABSs has started to get more clear, I've learned about some of the biggest risks that face ABSs, and I'm going to go through a few of them. First is conflicts of interest and ethical challenges. The involvement of non-lawyer owners in law firms raises concerns about potential conflicts between profit motives and ethical obligations. For instance, investors might prioritize financial returns over clients' best interests. The State Bar of Arizona is especially concerned that attorneys could be pressured to make decisions that could compromise their professional judgment. It's really important that ABSs follow the core principle of attorney independence to avoid ethical violations. Second is regulatory oversight and compliance. ABS entities are law firms. Like other law firms, they're subject to stringent regulatory requirements to ensure ethical conduct and protect clients. Non-compliance can result in severe penalties, including license suspension or revocation. In fact, there have been a couple recent disciplinary decisions related to ABSs and their compliance attorneys. Neither I nor my clients want to get anywhere near such a disciplinary action. The third issue is quality of legal services. Some people are concerned that the drive for profitability in ABS law firms might lead to cost-cutting measures that compromise the quality of legal services. Critics argue that some ABS firms focus on high-volume, low-cost services, possibly neglecting complex legal needs that require more personalized attention. My personal opinion is that lawyers already face that sort of pressure, and I'm not sure that it's much different in the ABS context, but I can understand the concern. Fourth is client confidentiality concerns. Non-lawyer ownership raises questions about the protection of client confidentiality. Unlike attorneys, non-lawyer owners are not bound by the same professional obligations of confidentiality, which could increase the risk of unauthorized disclosure of sensitive information. At Denton Peterson Dunn, when we represent ABSs, we draft confidentiality policies that will help protect client information. And when we train compliance attorneys, we always address this important issue. Fifth is the possible impact on traditional law practices. ABS entities, which are often backed by big capital and technological resources, pose a new competitive challenge to traditional law firms, especially small and solo practices. I've heard clients say that software is taking over the world and that finance is taking over the world. Both new software and new finance injections are a big part of many ABSs. Traditional firms might struggle to compete with ABS entities that offer lower cost services, possibly leading to market consolidation and reducing diversity among legal service providers. On the other hand, these new changes might decrease costs for some types of legal services. So what might be bad for some lawyers could be good for most clients. As time passes, we'll find out more about how ABSs are going to affect the legal environment. In the meantime, it's crucial for ABSs to manage the risks involved, so we help our clients do that. Our team is here to provide the expertise and solutions that you need.